My foreign-born spouse is in the United States, but our stepchildren are overseas. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. I've been noticing a trend the last few months, and that is that we've been getting a lot more calls from people where a U.S. citizen or green card holder marries someone from overseas, and that person from overseas has children back in the home country. And I thought I'd make a video to explain to you the different options that people in that boat have. Typically what happens is the foreign national gets a visit visa to the United States. Now, between you and me, they've told the embassy that they have children back in the home country, and that's one of the reasons that they're going to come back at the end of their non-immigrant stay, their 6-month stay in the United States. But sometimes they come to the United States and they fall in love, and those kids back home are still there. And the couple is thinking about, well, what do we do as far as it relates to the kids? And I wanted to make this video to walk you through sort of the two main approaches and talk about the strengths and weaknesses of each approach. Because the fundamental question is, do we apply for the children at the same time that we file for the foreign-born spouse, or do we wait until the foreign-born spouse gets his or her green card and then have them apply to bring the children to the United States? Both of these options are possible, and I've seen both scenarios. Having seen it many different times, I have a few thoughts on each approach. The first approach would be to wait to file for the stepchildren. And this is what happens 9 times out of 10. I think what happens a lot of times is that the couple is relatively new. They aren't necessarily ready to go full bore and try to bring the children to the United States. Sometimes they want to know if the marriage is going to hold up with USCIS, if USCIS is going to conclude that it's a valid marriage. And so instead of spending all that money on the spouse and the children's applications, they go ahead first with the spouse. I think there's also an element of the couple wanting to be together by themselves. Usually the U.S. citizen or green card holder who is here in the United States, they're the ones paying the bills. And I think sometimes they want to start their life with their new spouse without necessarily a bunch of mangy kids running around. So in this scenario, the couple meets in the United States. The foreign national is on a non-immigrant visa. They go ahead and get married, and they file a I-130 as the spouse of a U.S. citizen and an I-45 as the application for adjustment of status. The foreign national is trying to adjust their status based on their marriage to a U.S. citizen. That application can take some time, especially these days. In the old days, those cases would take 5 or 7 months. Now they take anywhere from 12 to 24 months. So let's walk it through. The couple gets married. They file for the adjustment. The receipt notices come back. The foreign national gets fingerprinted. Then they wait for their work and travel card. Maybe they use that travel card to go back and check on the kids. And then they wait for their green card interview. They have the green card interview. The USCIS officer concludes that the marriage is legitimate and approves the adjustment of status. Like I said, that can take anywhere from a year to 2 years. At that stage, once the person receives their conditional green card, they are free to file for the children. That process would then begin with filing I-130s for the children, and then consular processing after processing at the National Visa Center. That process itself could take another 2 years. So if the couple goes this first route and decides to wait to file for the stepchildren until after the green card is approved, you're looking at a separation between the parent and the stepchildren, their own children, of almost 4 years. So you really need to think that through. Because immigration is taking so darn long, you really might want to consider option number 2. Option number 2 involves filing both applications at the same time. I think the best way to do this would be to, after you get married, to file for the foreign-born spouse's green card, like I said, based on the I-130 and the 485, get that receipt notice back, and then go ahead and have the U.S. citizen file for his or her stepchildren. They would do that by filing I-130 petitions for each child. So if there's 3 children, that would involve filing 3 new I-130s. The filing fee for that is currently $535, so I understand why people sometimes wait. But if they file for the child or the stepchildren overseas, then those cases can go on the same track time-wise as the case here in the United States. So you would actually have the spouse's case going along at USCIS while the children's cases are processing at the USCIS Service Center, and then at the National Visa Center, and then at the embassy. You would probably have the spouse's case approved and would need the spouse's case approved before you file for the children. But the great thing about this approach is that the children's time waiting would be essentially cut in half, and they would be able to come in about 2 years instead of 4 years. The other reason why you might seriously consider this option is because sometimes the stepchildren might be in risk of aging out. We've had some pretty smart clients or potential clients reach out to us who are thinking about when they should file for the stepchildren, and they wisely realized that the stepchild was 19 or 20 and that they might turn 21 if they waited for the non-citizen to get their green card before applying. Hope that makes sense. But basically, they decided to have the U.S. citizen apply for the stepchild sooner than they might have otherwise because they didn't want the child to age out and to go into a different visa category and really have to wait years and years to be able to come to the United States. So those are the two approaches. Obviously, there are a ton of practical real-life concerns in which approach to take, and that's why I think 9 times out of 10, maybe 8 times out of 10, the U.S. citizen and the foreign national wait to apply for the children. But I wanted to shoot this video just to lay it out there for you with my mindset that from a purely immigration standpoint and from the immigration delay standpoint, that the fact that cases are taking so darn long and that the separation between the non-citizen spouse and the children could be up to 4 years long, that you might want to think about filing for the stepchildren sooner rather than later. And of course, that's especially true if the stepchild is in danger of aging out. Hope this all makes sense. Hope that you enjoyed this video. And this obviously doesn't apply to everybody, but we think it'll be helpful for those for whom it does apply. If you have questions, feel free to shoot us an email, info@hackinglawpractice.com. You can call us at 314-961-8200. You might know this, but we have this Facebook group. It's called Immigrant Home. We have thousands of members in that Immigrant Home group, and people are talking about their immigration issues and processing times and what's going on at the embassy or at the service center in that group every single day. You should really think about joining it on Facebook. And then lastly, we have our YouTube channel. Obviously, if you're watching this, you're probably watching it on YouTube. We've had that channel for like 10 years now. We're well over 50,000 subscribers. We'd love to have you subscribe. And when you do subscribe, you'll find out first when we go live on our Immigration Answers show, which is usually done about 3 or 4 days a week. It's just basically a call-in show on YouTube where I answer people's immigration law-related questions for a full hour for free. So think about joining us there. Thanks a lot and have a great day.